I'm Keith Hittner, Senior, your Realtor, and today I wanted to share with you the best practices for the probate process Minnesota regarding real estate. This is part of a series of videos that we have produced regarding the probate process Minnesota. So how long does probate take in Minnesota? How much does an estate have to be worth to go to probate? So what is probate? Probate is the legal process of settling your estate in court after you die. Your property is gathered and inventoried, your debts are paid, and everything left over is divided amongst your heirs. Your personal representative is responsible for probating your will. If you have no will or did not name a personal representative, the court will appoint one for you. Probating a will begins by filing an application with the probate court, and probate ends when all debts and taxes are paid and all assets are distributed. If there is disagreement over your will, a probate judge will resolve the differences. When is probate necessary? Probate laws in Minnesota apply to the estates of people who were residents of Minnesota at the time of their death. Probate also applies to other states' residents who own real property in Minnesota. Having a will does not avoid probate. The need for probate depends on the amount of property you own, the type of property you own, and whether you own it alone or with others. Real estate Minnesota probate laws state that unless the real estate is joint owned in tenancy with the right of survivorship placed into a trust, it must be probated. Joint tenancy means that the property is owned by two or more people who have an undivided interest in the property, and that interest continues in the survivor after the owner dies. If you are a resident of Minnesota and own real estate in another state at the time of your death, the probate laws of that state will apply to that real estate. In other words, real estate is probated in the state where it is located. Personal property, if your estate is worth $75,000 or less, your heirs may be able to collect the property without going to court by using an affidavit for collection of personal property. Heirs may not take your personal property until 30 days after your death. If your personal property exceeds $75,000 or you own real estate in your name alone, your estate must be probated. What items are not subject to probate? Well, some kinds of property and assets do not need to be probated. These include property owned as joint tenants, jointly held bank accounts, payable on death accounts, life insurance, proceeds to a specific beneficiary, and pension benefits with a designated beneficiary in the event you die. Joint tenancy property, as discussed previously, holding title to the property in joint tenancy means that you and another person each have an undivided interest in the property and a right to own it after the other person dies. In the case of real property, this fact would be stated in your title documents when a co-owner dies. The surviving property owner must file a certified copy of the death certificate of the deceased property owner and an affidavit of survivorship within the county recorder or at the registrar. Payable on death accounts, otherwise known as PODs, a payable on death account is an account in which you choose someone else to receive the funds in your account upon your death. The beneficiary or person getting the money upon your death has no right to these funds until your death. You may set up a POD by contacting your financial institution. You may change the beneficiary by completing a new signature card at any time. This is important because that option is also available to real estate. That is, upon the death, the property ownership is transferred to any individual or group of individuals that you choose and set up prior to your death. The transfer on death option may avoid the need for probate altogether, depending on the remaining assets in the estate. And this will speed up the process, allowing you to close out the estate in a more timely fashion. In the next video, we'll discuss how an estate is probated. These videos are not meant to be legal advice. If you are planning your estate or have been named as an executor of an estate, I advise you to seek competent legal advice. I have included a link below to a download ebook discussing probate and planning. This ebook can act as a guide for planning for the future. It outlines the basic elements of probate and in an easy to understand format. Probate in all but a few cases is a complicated matter, and you should enlist the services of a professional to help guide you through the process. In most cases, real estate is a significant asset in an estate and needs to be probated. The disposition of that asset should be considered carefully. A real estate professional who is knowledgeable in this area is critical to avoid common pitfalls, mistakes made by inexperienced and unknowing practitioners. Now, in this series, we speak with attorneys, counselors, life coaches, and others who add valuable insight and guidance to the topic of probate in Minnesota. Now, I'm Keith Hittner, Sr., and over the years we have helped hundreds of clients who are working through probate after the loss of a loved one. The sale of real estate and the distribution of the proceeds to the heirs of the estate are part of that proceeding. Watch all the videos in this series and any additional videos as they become available. Subscribe to be notified as new information is added and updated.